have two groups to begin with. The third group has come later on. 341, 342A has come later on in 2018, leaving that for the time being. Two groups were sought to be created and then divide them for the purposes of red and green, as I gave that. I was wanting to give that simile, my lord. The threshold why I say so is that yes, they are heterogeneous, but they have these common traits in themselves, the basics ones, which I call the red ones. They are shades of red. Indeed, they are. It has been emphasized very largely on the other side that heterogeneity, yes, it is.
But what do you mean by
that
wisdom, common traits?
That wisdom, I'm sorry.
Mr. Mansoori, what do you mean by common traits? Apart from the fact that all of them have faced varying degrees of discrimination in the past, what is a common trait of different entries?
Not the
discrimination is common.
Yes.
The fact that all of them face discrimination, social discrimination,
Yes.
is common.
Yes.
But can we say that other traits are common? I mean, what are those traits? Social backwardness,
There could have
economic backwardness, lack of resources, educational backwardness.
Yes.
The social indicators like infant mortality, maternal mortality, age of marriage of women. So typically, the earlier the age of marriage, it's always considered to be as societies become more progressive, the age of marriage of girls always increases. So that's also regarded as a very important. Then life expectancy. The more undeveloped community, the lower the life expectancy. So
what was your lordship's query? That what was that threshold? Your lordship's query. Lord, I would respectfully submit, my lord, that backwardness alone. It may be social backwardness. It may be educational backwardness.
So according to there was one common trait, namely discrimination plus backwardness.
And that ought to have been, and that was, it has to be presumed, my lord. Why? Because that exercise is being done under 341(1). The president of the country is consulting individual states and union territories. The governors are being considered. They have the advantage of the local scenario. It is assisting the president, and he in consultation, and that elaborate consultation process has been elaborated by a lordship's judgment, my lord, in Bir Singh and all those judgments. Yes, my lord. It's an elaborate inquiry. The state has a full say in it. The state had a full say at that time. Yes, that is the stage. And that alone is the stage where the state comes in.
Right.
Is my respectful submission.
Fair enough.
They have a say. They are not a mute spectators. But what say, as I submitted, my lord, to begin with, the scheme of the constitution.
Now just tell us this. I've gone to your second. We have, I think, gone to the first and second bullet point under serial number 1. When
Yes,
you say as amended in 2018,
yes,
then you have to say that there was a proposal for insertion of 341(3) in 2000. That was following the Usha Mehra, Justice Usha Mehra report.
Yes, my lord, yes, yes. Lord, permit
Was
me.
that moved as a, was it a bill which was ever moved for amending, or
No, no,
it was just
it was a proposal, and the proposal said,
proposal at what stage?
it was a proposal right after the judgment in Chennai. Lord, just after right after Chennai, this
amendment was related to reservation promotion, no?
give me the language of it. Give me the language of it.
This in volumes for page two.
Reservation and promotion is different.
Completely different. Completely.
Not for this matter.
241.
Lord, there is something.
See, yesterday when we were reading that report of Justice Usha Mehra,
Yes.
she at the end, the learned judge says that it is proposed that we propose that Article 341(3) should be included, right? But when you say proposal, we just want to know, was
Lord, there is some assistance.
there any
There is a-
bill? Was it referred to a standing committee? Did the bill lapse, or didn't come to that stage at all?
Lord, I'll investigate that, Lord, very frankly. But this, what information I have is that this was referred to the Justice Usha Mehra committee.
Other side may also just find out, a little bit, Mr. Farah sir, on what happened to that 341(3)
Certainly,
bill.
my
Just
lord,
a matter of historical importance.
Certainly, my lord. There's something that turns on an assistance in this regard, my lord, that what was that content and why and what was not accepted. What was suggested by Justice Usha Mehra's committee was an addition to 341(3). And the language is this: Parliament may by law provide for subcategorization or de-subcategorization of castes, race, tribes, or parts or groups within any caste, race specified in the notification issued under 1 or by a law made by the Parliament under clause 2. It was suggested that there can be subcategorization. Not accepted. Right after Chinnaiya.
It didn't go to the parliament at all, so what?
I'll be very clear on that, my lord, then make my submission on that. Lord, bullet point 2, my lord, if I can elaborate, in item 1, 342A. Lord, 342A is an 2018 endeavor. And 3 things are coming, Lord, in 2018. We are having to add 342A, 338B, and 366, 26C, all in tandem with each other.
2018 amendment brought in.
Brought in, my lord, 342A, the entirety of it,
Yes.
which has A,
Then
and my lord, it brought in 338B, which is a commission for the same purpose, SEBCs, and my lord, it brought in the definitional in 366, in 26C. It brought in these 3 things. Lord, what is the submission that follows is that they borrowed the 341, 342 model. Now we have the 1992 judgment Indira Sahni. We have all the other judgments. And my lord, when I take your lordship to the select committee report, they are saying that Honorable Supreme Court in Indira Sahni wanted us to make a permanent commission. And that 340 commission is not the statutory constitutional commission. There is a commission, but it is the experiences of the SEBCs. That is not a statutory commission. That is not a constitutional commission. We want a constitutional commission for this purpose also, which will investigate and suggest the working on the ground. To put it very briefly, yes, it was a direction which is implemented now in 2018. Submission I am making vis-a-vis 342A is, my lord, that the constitutional march appears to be in the direction of 341-42. That is, have a presidential order. Please don't have this backward and more backward. Indira Sahni model was a model, backward, more backward in SEBCs. They are specifically saying, so please don't have that model. We please have a model of 342A for SEBCs. That is, President will consult the states and will come out with a list. And the variation will only be by the Parliament by law. Lord, I wanted to further emphasize the implication of 341(2), my lord, as a sequitur, my lord, to this scheme of the Constitution. My lord, therefore, advisedly in 341(2), expression is being used, include or exclude. It is in tandem with 341, my lord. Absolutely in tandem with 341. Because in the president has...
The parliament finds that a particular caste has reached, has come to a mainstream. And parliament can exclude that from 341.
Yes, my lord. My lord, why the word vary was not included in 341(2)? I ask myself this question, my lord. Only include or exclude. It's crucial to bring to your lordship's very kind notice, my lord. The expressions used in 341(2), akin to 342(2) and all these, the second part of the 341 chapters is include in or exclude from. Why? Because they are all they are now deemed to be. This is a constitutional list, as my lord the Chief Justice put it. My lord, this is a list born out of the Constitution, never before. It couldn't have been a caste, my lord, because it would have been foul on 16(2). 16.2 specifically says, please don't discriminate on the caste. Tribe incidentally is not there in 16.2, but caste is there. Therefore, Thomas says very specifically, this is a class. This is a special class. I'm using the exact phraseology as used in Thomas. This is a class. This as a big run up to discussions in 165 paragraph, the Honorable Court says that in Thomas, that this is a class, this is a special class. Para 165. Therefore, my lord, I would respectfully submit that very advisedly, it is in 2 that include or exclude. There can be no other shade of variation. State still has no role. It will be done by the parliament. And parliament by law will only include or exclude. Why? Because this is all homogeneous now and deemed to be homogeneous. You can't pierce that veil. That appears to be, my lord, in my most respectful submission, the use of the word deemed. That please don't pierce that. Either include or exclude. And my lord, that fresh experience is not shut out. It is in 2. The fresh experience will be translated in this fashion. The state governments will have a fresh experience. They will send it to the commission. There is a commission now. There was always a commission 338, the likes of 338 for all the 3 categories. There's a commission. Please send it to the commission. Commission is an expert body sitting there. It's a constitutional commission, a route created. That's the other submission. It is a route created, a constitutional route already suggested. And if suggested, my lord, any other route will be out, will be excluded by necessary implication. The route is that please, you have fresh experience. Yes, of course it can be a fresh experience. Nobody can say that fresh experience has no ventilation. Yes, state governments will send it to the commission. The commission's report, as per the language of 338, to be put before the parliament. Copy to be sent to the state legislature, to the state governments. To be sent to the president. The president will exercise 341(2) and will include or exclude. No vary there in 341(2) also. Even the president cannot vary. I would respectfully submit on the scheme of the constitution. And further indictment, further indication, if I may say so, in 341(2), that the author of 341(1) is injuncted that please don't vary it. Why? Because remembering the words of Dr. B.R. Ambedkar. 2 things he said, my lord, only one thing has been emphasized before your lordships. That famous paragraph, which is often quoted. He said, political factors and disturbance in the list. He said 2 things, my lord. Please don't cause any disturbance. Disturbance is far more, my lord. Political factors is 1, disturbance in the list. Goes hand in hand with no variations. State still doesn't have a role. I've completed 341, 342. State doesn't have a role except 341 initial part. You will be consulted. You, the state government, will be consulted. Your point of view will be taken. The call will be taken by the Honorable President. He will make a list. But this last bullet point on 1 is just to give an illustration, my lord, that when we see, this is on the threshold, my lord. The summation is that when we see 41(6) for economically weaker sections, we find that a threshold has been prescribed, my lord. That somebody whose income is this much, is below this, is eligible. So therefore, there had to be a threshold catchment point. Otherwise, if I'm going to have a 1-to-1 ratio, I'll have to have 120 entries. It will be unworkable. I'm grouping them together and then I'm protecting it by a deeming fiction for the purposes of this constitution. And not, it can't be argued, as it was argued on the other side, that when I make 341, I am making that list and it has got nothing to do with reservation, because the earlier sections are talking of reservation. These a category, the identification of 341 is identification for the purpose of this constitution. Wherever I need to talk of scheduled caste, scheduled tribes, I will be taking the identified category from 341. Not to say that 341 has nothing to do with a reservation. Why? Because reservation word is not used there. It is contained in a different chapter. It's contained in chapter 13. 16.4 is contained in part 2, in part 3. But that takes me to summit. This EWS example is for that purpose. Two.
So what is your formulation on the EWS point?
The summation there is, that this is a threshold, yet another example in the constitution, that threshold prescription, which manifests itself. 341 is an exercise which was done by the president. We don't have the access to that. This is an exercise which is out and to be read. So 14.6, 14 bracket 6, 14 bracket 6. I'm 14.6. 16.4. 16.4, is it?
Yeah, you said 14 by mistake, that's it.
No,
No, I'm sorry.
It's 16.6. Nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any
Yes,
economically
yes,
weaker
please.
sections of
Yes.
settlement, other than the classes mentioned.
Yes, but the 16.6, nothing in this act to prevent the state from making any provision for reservation of appointments or posts in favor of economically weaker section of citizen other than the class, in addition to subject to a maximum of 10%. And here, my lord, there is a prescription of the economic threshold. Yes, there is a prescription of the economic threshold. That is to say, my lord, that in a classification, one-to-one relationship is difficult to achieve, and that was not the policy, that's not the scheme. Basic traits being found, grouped together. Nobody is questioning that. So to begin with, we did have heterogeneity, but then the constitution requires us, my lord, that this is a constitutional class now. This is not a caste, otherwise it would have been bad on the language of 16.2. No classification on the basis of caste. This is a class.
Now, for the purposes of Article 16.4,
Yes, my lord.
when the expression that is used is backward classes, it will include the SCBCs,
Yes, my lord. Yes.
it will include the SCs
Yes, my lord.
and the STs.
Yes.
So OBCs, SCs and STs.
Yes, my lord.
Now, for the purpose of Article 16.4, does the expression backward classes means the entirety of the scheduled caste as one conglomeration, or can it refer to individual entries in the presidential list also as a backward class?
Yes, my lord. My
Can we
submission.
deny the fact that an individual entry in the presidential order is also a backward class? If it is a backward class, then 16.4 would recognize the power of the state to make a special measure in relation to that particular individual entry as well.
Yes, my lord.
On the other hand, if we say that no,
As a whole.
the scheduled caste as a whole is a backward class,
Yes.
then that is not permissible.
Yes, my lord. I would say the later, my lord.
Why?
I respect your submission. And why, my lord? Throughout the constitution, your lordships would find only one expression coming when I take your lordships to 335, the efficiency. When I take your lordships to the other 46, when I cite 46, your lordships have seen it over the last 2 days repeatedly. Expression scheduled caste, scheduled tribe will occur as such. And even 16.4, kindly see, in
So
favor of.
interestingly, look at when we understand the interface between 16 and 341, we must recognize that in 16 itself, certain restrictions or certain measures can be imposed only by Parliament. So 16.3, state has no role. 16.3 is only Parliament. It says nothing in this article shall prevent Parliament from making
Any law.
any law.
Lordship.
16.4, on the other hand, says state,
Yes, my lord.
which will include the union
Yes, my lord.
as well as the state government.
Lordship, yes.
It refers to provision, not just law.
Lordship.
So when
Executive order can be
likewise
there.
16.4a state, 16.4b state,
Lordship. Yes, my lord.
16.5 and 16.6,
Law by law.
16.5 law,
Law.
16.6 state.
State. Make any
Now,
provision.
therefore, the provision of 16, while 341 left the designation to Parliament, 16 by itself recognizes that the states will be implementing these special measures
Look,
or
may
making any provision,
provision.
as 16.4 says.
may I just, I'm sorry.
So the role of the states is directly then
Yeah.
recognized by 16.4.
They have a role, my lord, but what role is important, my lord? They have a role. Because that picture of 341 is incomplete without 16.4. 16.4 will have no meaning if 341 exercise is not there. That's how they're interrelated. So therefore, as my lord the Chief Justice asked me, what is 341, my lord? And my respectful response, identification process. But can the state take upon itself the identification process is the question I ask myself.
No, they can't do that.
It can't do
There's
it.
no question of identification.
They have no role in identification.
16.4 also
Yeah.
is only an enabling provision.
Lordship, yes.
Suppose if the state decides that it will not provide for reservation.
Before the vehicle moves forward,
Any of the matter. Yeah.
I'm sorry.
No necessity to provide reservation. That's the end of the matter.
End of the matter. Yes,
Therefore,
it can be done.
Can you deny the ground realities that in a list, blacksmiths are there and scavengers are also there? Did they face the same degree of discrimination when they are brought in the list? Were they not untouchables among the untouchables? And therefore, if recognizing that, if the state decides to provide among that class a preferential treatment, would 341 come in that way?
Yes. Lord, my respectful submission is, my lord, that exercise, my lord, is an exercise which has been done in 341. And the shades of red and the shades of green have been identified.
No, no,
And-
it's exercise of identification of the classes or groups
Yes,
which suffered from discrimination.
have been identified.
But they don't go, serial wise that higher the number in the list, the more discrimination or lesser than, if it is serial number 15,
Yes, my
the
lord.
least discrimination.
Yes,
So if the state,
yes,
it is for the state in order to achieve social and economic justice
yes.
to provide for reservation. And while doing that exercise, if it tries to find out that among that class, who are the more disadvantaged and does some special provision for that, would it be barred by 341?
Yes, my lord. My respectful submission is that it would be barred by 341, and the reason
Then,
is
then,
this.
then it will perpetuate the inequality among those classes.
Yes, my lord. Yes, yes. But I'm aware. That's a submission, Lord, that's a submission on the other side, and that's your lordship's query to me, my lord. May I respectfully respond? My lord, this submission that comes from the other side is really questioning 341 exercise.
No, not at all.
So, because, after N.M. Thomas, it has been held that even if 16.4 was not there, still taking cue from Article 14 and 16.
16.1.
16.1.
Yes, my lord, it
the
could have
state-
been done.
state could have made reservations.
This is an equality measure.
Because the purpose is to remove inequality, so as to bring them equal.
Lordship, yes.
So, if your submission is to be accepted, take for example, a particular caste in Maharashtra. For last 75 years, if a particular caste has been occupying 75% or 80% of reservation, among that 13% reservation, and there are some castes which have a sizable representation, but they don't have even 1 or 2% reservation. So would it not amount to perpetuating inequality amongst that class which has been identified under 341?
Lord,
And if to remove that inequality, if the state decides to do some exercise under 16.4
Lordship, yes, Lord, that's a submission.
or 15.4,
Yes, Lord. The question that is being asked.
because
Yes,
341, if state does not provide for reservation, it only provides for what would be scheduled caste.
Lordship, yes.
And then the reservation is provided under 16.4 or 46 provide that it shall be the duty of the state to make special provisions for advancement of scheduled caste, scheduled tribe and backward classes,
Well, I would,
or for the purposes of 330.
Lord, I would respectfully submit, my lord.
Would it not hit at the very concept of Article 14?
Yes, Lord. I quite see that, my lord. I quite see that. May I make my respectful response to what comes from my lords, my lord? I would submit, my lord, that this is the precise scheme of the Constitution. The scheme is that we will identify. And when identified, this submission that comes from the other side is actually questioning the scheme itself.
No, they don't question the scheme.
I,
They don't say that the identification is not correct. They
Yes.
say that among that identification,
allow us.
there are
Yes.
certain classes which are more disadvantaged,
I quite see that.
and therefore allow us to bring equality in the real sense.
What is being put to me is, my lord, this, that having identified, say 39 in Punjab, we have 39, exactly 39 in Punjab. Why can't the state, what is being put to me is, why can't the state say that on experience we find that Mazhabi and Valmikis, they deserve some extra preference, 50%
Special treatment among the special.
amongst the special. Why can't they say, especially your lordship put it to me, in view of 16.4? Why? Because is it not an equality doctrine which is being followed by them? And if they are doing it, what is wrong? Where is the bar? That's as I understand the question. My respectful submission is this, Lord. This exercise of equation has been done, and there is a mechanism to change it. And there is
Change it, you yourself argued
yes, Lord.
that there is no provision for variance. So either include or exclude.
Yes, Lord.
So if there is neither a necessity for inclusion
Yes.
nor a necessity for
To
exclusion,
exclude. And
but still there is a situation
yes,
that some classes among that class under 341
yes,
have reached a particular level
yes,
and others are still at the bottom.
yes,
Would some tinkering in that
yes.
would not be permissible without touching the
The list
special,
itself.
without touching the list or the special provisions to everyone who are included in that list?
Lord, kindly see me, Lord. This exercise, Lord, therefore the word deemed comes, my Lord.
One more
Lord.
aspect you need to consider.
Lordship.
In 4,
Yes, my Lord.
it says any backward class.
Yes, my Lord.
That's the widest term used. There are 3 lists, 341, 342, 342A.
Lordship.
Can the state not identify another class as a backward class which is not included in 341, 42 and 42A?
It is being said so, my Lord. It is being said so
No.
that
The
this
state
is
do it or not?
My Lord, I can, I'm sorry, my Lord.
Can the state do it or not?
Lord, it
Under
is,
16.4.
it is being said and authoritatively said in Indrasani that 16.4, please don't read it as limiting the power.
Correct.
Because the opening words are, nothing in this article shall prevent the state from making any provision.
And significantly,
Yes.
16.4 doesn't use, it uses the expression backward class.
Yes.
It doesn't use the socially and educationally backward
Nothing.
class as it is.
Any backward class.
Any backward.
But
class.
at the same time,
Yes, my Lord.
but at the same time, it doesn't use the word caste or tribe.
Right.
Raster tribe.
It has to be a class as a whole.
Yes, my Lord.
So
As a-
the state would have the powers to make reservation for the backward
Class.
class,
Class.
not for the caste or tribe. So that fine distinction.
Class may not be
Because-
there in 341, 42, 42A.
Backward class which is not adequately represented.
Yes,
That has to be seen,
Yeah.
not a particular caste.
yes. Otherwise, my Lord, my Lord, I'm very grateful, my Lord. Otherwise, that will be classification on the basis of
There is
caste.
a difference between caste and class.
Yes.
And see, all this would fall under SC, the backward class would include SC, ST and SEBC.
Lordship.
So that would be a class by
Class by
itself.
yes.
It's not caste.
So class benefit is contemplated. Lordship, yes. Lordship, Lordship, yes. Benefit can accrue to a class as a whole. And Lord, kindly see the facts in Thomas. Lordship, yes. Yes. Yes, yes. Lordships,
Tell us one thing.
Lordship.
Does Indrasani continue to, insofar as subcategorization is concerned?
Backward and more backward.
Right.
Yes.
It permits that subcategorization for the
Indira Sahani did.
OBCs. We'll call them OBCs just as a.
Backward, more backward.
Now, Indira Sahni permits the subcategorization.
It does.
Is Indira Sahni overruled by the 2018 constitutional amendment?
My lord, it substantially, my lord, when I take your lordships to the debate, it's very interesting, my lord.
Indira Sahni continues to be good law. What does the 2018 amendment for Article 342A do?
It does this, my lord.
See,
Sorry.
Under 341 and 342, in relation to the scheduled castes and scheduled tribes, exclusive power is vested in Parliament. Right?
Lordship.
What 342A does is that each 342A breaks it into two. It gives the exclusive power to Parliament in relation to the central list for the purposes of the central government,
Yes, my lord, yes.
right?
Yes.
342A1 refers to two things: the central list for the purpose of the central government,
Yes.
right?
Yeah.
341 says for the purpose of the constitution. That's the other distinction. Now, 342A clause 3
State.
allows the states also
To have an independent list,
for the
separate list.
for the purpose of the state.
States.
In fact, it says for the purpose of the state.
Yes.
Every state or union territory may by law prepare and maintain for its own purpose.
Purposes.
So it has bifurcated 341 and 342 into two
Yes.
by giving the states also the power to notify.
In regard to SEBs.
Now, notwithstanding this, the logic of Indira Sahni in regard to subcategorization into the backward and more backward is not taken away by the 2018 amendment which was made by Parliament. They could have done it, but they have not done it.
But kindly see,
Therefore, the logic of subcategorization in relation to the OBCs, which was brought about in Indira Sahni, still continues to hold the field, notwithstanding the 2018 amendment.
Lord, kindly see, my lord.
Now, if that is so,
Yes.
would it not be appropriate to then to read that the power of subcategorization is also implicit in 16.4 itself?
Kindly see, my lord. 342A.
Subcategorization which 342A permits is not subcategorization, is actually, I'm using
Two
the wrong
lists,
phrase.
two lists.
It contemplates that there can be two lists.
Yes.
A central list for the purpose of the central government,
Yes.
a
State list.
state list for the purpose of the
State.
government. So what is the distinction, as I said, between 341, 342 and 342A?
For the purpose of the
There's only
constitution.
one list,
Yes.
list made by Parliament. Two, it is for the purpose of the entirety of the constitution,
Lordship, yes.
right?
Yes.
Now, is there something intrinsically in 342A which would indicate that 342A recognizes the power of subcategorization, which 341 and 342 don't? The hypothesis which I want to place before you is, there is nothing in 342A in regard to subcategorization, just as there is nothing in 341 and 342
Yes.
in regard to subcategorization.
There's nothing.
Despite that, Indira Sahni recognizes the power of subcategorization between the backward and the more backward. And 342A was not there when Indira Sahni was pronounced.
Lordship.
So even before Indira Sahni, even before 342A is brought on the constitution by the 2018 amendment, our court reads the power of subcategorization. Where does it locate it? It locates it not in 341 and 342, but it locates it in 16.4. Therefore, the insertion of 342A does not alter that position.
Lord, I would respectfully.
If that did not alter the position, though Parliament could have while making the constitutional amendment, then why do we recognize it in relation to scheduled castes also?
Lord, I would respect.
At a conceptual level, Brother Gavai just said, for instance, otherwise what will happen is that the more advanced among the scheduled castes, they will grab all the benefits. In fact, Brother Gavai, you can tell that example of the MBBS.
Yes.
Maharashtra,
Yes.
till 1985, there was not a single candidate from Mehtar community who had got admission in MBBS. So for the first time in 1985, that too through court, he could get admission. Unfortunately, I was his lawyer.
Fortunately.
Fortunately.
Very fortunately.
Must be a super specialist.
So from that, so he didn't go to that. He became a doctor, MBBS, got a government job. He became a doctor, came and met me with a packet of sweets. So that was one of the most happiest moments for me, that it was a pro bono case. For 35 years after the constitution came into,
I may say so, fortunately, you're a judge now. That's also fortunate.
for 35 years, and it is one of the most disadvantaged. Whether Vangi, they have to do the job of scavengers. Yeah.
Not responding to, not making a.
Now the position in at least in Maharashtra is that sometimes the merit list for MBBS of general category and the SC category is almost same. Because of Indra Sawhney, many of the scheduled caste persons get admitted in a general category because they can compete with the general category candidates. Because Indra Sawhney says that those who are admitted in category, they can't be counted in scheduled caste category or scheduled tribe category.
I mean, it's not sub-categorization, it is categorization for the purpose of definition.
Reservation.
SEBC
Nuance.
Categorization for the purposes of giving a beneficial treatment so as to remove inequality.
Correct. So it's not sub-categorization as such. Constitutionally, not per se sub-categorization. You are saying you're giving the benefit, we rather give the benefit, this much of benefit to A, because B is getting all the benefit.
It is, and to bring equality among that class. Covered by 341 or 340.
Equality is in categorization.
Your rejoinder, and Mr. Gurmeet Singh, you will have to deal with this point which Justice Bela Trivedi just made, that 16(4) contemplates that you take whatever makes special provision in regard to a backward class.
Yeah.
And suppose you say these two castes
That's a reason.
are going to get preferential allotment. Would that be doing violence to the language of 16(4)?
Not at all, because
Yeah, just reflect on it. I mean, because, we like a response. We'll just leave it at this. We'll just flag it and you can deal with it in your rejoinder. But I might forget to ask and then I'll realize at the end of it all that I didn't ask.
already.
Lord, may I make a respectful response, Milord? Lord, there is in 16(4) vis-a-vis 342A, my Lord the Chief Justice's question. I would respectfully submit 342A, which was not there, of course, at the time of Indra Sawhney. We have that now the list will be prepared and there is a similar deeming provision in the opening of 342A.
342A is identical to 341 and 342.
Yes, my Lord.
Save and except for bifurcating the power. It says now the central government, there can be a central list for the purpose of the central government. There's a state list for the purpose of the state government.
Yes, Milord. So, Milord, I was drawing the point that how have we moved away constitutionally from Indra Sawhney? That was my Lord's question, Milord.
Yes.
Milord, I would therefore wanted to read 342A, the first part of it, that unlike then, in 18 now, we have who will identify. We didn't have the benefit, obviously, of 342A in 1992, when Indra Sawhney was decided. The later experience, what is brought about is the president may, with respect to any state, union, territory, or where it is a state, after consulting with the governor, by notification specify socially, educationally backward class of citizens for the purpose of this constitution, which shall be deemed to be socially, educationally backward class.
15(4). When 15(4) used the expression the state, 15(4) used the expression socially and educationally backward classes of citizens.
Yes.
Right? So backward class will also include socially and educationally backward class of citizens. But 15(4) made it implicit that when it said state, the center could identify it and the state could identify it because of the purpose of the central government special measures.
The difference, Milord. Milord, the difference.
Scholarships by the union government and the Ministry of Human Resources Development, they can identify. States can do it for the state civil service, state scholarships. I'm just giving you an example. So what The 338A now does is expressly recognize that, for the central government may do it for its purposes. To that extent, there's a little variation from 341 and 342.
No, there is indeed, because 3 is there, 342A3 is there, that is the variation. That variation is there. Not what further variation that has taken place and why we have moved
Could
away.
that be an
from-
indicator? I'm saying something in your favor. Could that be an indicator that insofar as the model for the SEBCs is concerned, it's a little different from the model which the Constitution adopts for the SCs and STs?
Certainly, my lord.
I mean, if we are still,
there has to be a
we are
respectful
thinking
answer
about the
in this.
problem, that's something which we can put in your favor as actually.
Lord, that has to be respectful answer. Yes, Lord, there is a difference. Lord, I was wanting to make this further submission. That we have a model identical in 342A, where the identification was earlier being done by the government, Indira Sahni, of the SEBCs, the OBCs. But now that identification is identically being done as 341 by the Honorable President. That is why we have moved away from that. And when it was left in the hands of the executive, it could be backward and more backward in Indira Sahni. But now we have an identical model of 341-42 to say that exercise will be similar. President will do it. He will consult the government, state governments, and he will prepare a list of SEBCs for that individual state. That's where we have moved away constitutionally, my lord, is my respectful submission.
All right. So now we have finished your item 1. I think your point 1.
Yes,
Now you can briefly deal with Thomas because
yes, my lord.
so then you
My
can
lord,
proceed
permit me
ahead.
one submission, my lord. My lord Justice Gawai was pleased to ask me on 16.4 if I can respond to that, my lord.
Sure.
Oh, permit me that, my lord. Indulgence. Lordships put a question to me. Identification has been done. There's no difficulty. They're not wanting to tinkering with that. Once they are wanting to get the benefit, if they don't prescribe under 16.4, you will get nothing. I get nothing. But if they prescribe in 16.4, then why can't they address the iniquities which are obtaining within the entries? This is the question as I understand, my lord. My lord's question. My lord, my respectful answer is this, my lord. That this entire exercise has been done in 341.
Entire exercise of
identification.
identification, of
Lord, further.
social discrimination.
Yes, Lord.
But not the degree of discrimination.
Yes, Lord. Yes, yes.
We are again coming to square.
I have to make a further, Lord, this is a sequitur that I must submit further. This is the first part of
As
this.
the ground realities are that among the untouchables are also
Yes.
some untouchables treat others in that list to be untouchables.
That disparity, how is it to be addressed, and why, if the state is giving the benefit under 16.4, why is it, where is the bar, is my lord's question.
So to remove those disparities,
Yes, Lord.
if the state is doing some affirmative action,
Yes, Lord. Lord, my respectful submission is on the scheme of the constitution. That there is, if that inequality is there, then what is the scheme of the constitution, as I respectfully submit to your lordship's kind consideration. Lord, exercise of identification having been done in 341 and the imposition of the word deemed, they become a homogeneous class.
You made the point. You got
They
the
become a homogeneous class.
once they are part of the class, then there can't be any
I've got the point.
interest in
We'll
discrimination.
have to
among-
hear the other
Yes.
side now. In
And that's the constitutional mandate, as I respectfully submit, Lord.
Now,
Having said
let's-
that,
now, let's move ahead. Now we must make some headway now because that I think we have also asked
I
the
have,
questions and we have,
I won't go point wise as I see it, my lord. I have
Alright.
covered, I've covered 2, 3, 4 more points as I am making a submission, my lord.
Thomas, because that's your item. You can just at
I
least
will not permit
maybe a
me this.
minute or two because Thomas we have read, but you can make your point on Thomas.
I will not just 1 or 2 lines on Thomas and.
What do you want to say on Thomas?
Can I seek indulgence to make a submission on 16.4?
All
Can I
right,
seek?
go ahead, no problem. That is your point 4?
Yes, my lord, 60, yes, that's the last dot on that. On 16.4, my lord, I was wanting to answer the query.
Right, all right.
My lord. Why can't they address that question? Lord, that question has to be addressed. I can't be submitting that inequity cannot be addressed. It has to be addressed. But by whom? We have a constitutional commission now, 338B, the likes of 338 for all the 3 categories, SC, ST, and even for SEBCs also we have now. Concentrating on scheduled caste, we have 338. A constitutional commission. So that experience will then go to the commission, will then go to the state governments will have a feedback. That report will be placed before the parliament, will be placed before the state legislature, will be taken to the president, and he will include or exclude. Therefore, Millard, I submitted right in the forefront that the power very instructively, Millard, very, very importantly, in 341(2) is only include or exclude. Why? Because this is in tandem with one. Deemed first to be all equal. Now you have fresh experience. I will exclude or include. It's not as if there's no ventilation for fresh.
That's what you argued in the beginning. The power is only to either include or exclude, not to vary.
Yes, to vary. So there is room for fresh experience as it ought to be.
There's no middle path according to you.
I'm sorry, Millard.
There's no middle path according to you.
I would submit, Millard, and not on the annual of 16.4. So 16.4 is not the route.
That we already appreciated your submission.
Yes, Millard, because 16.4 is.
We have understood that submission.
Yes, Millard. I was just wanted to emphasize this. 16.4 is, I am the state government. I can prescribe. It's my prerogative. I may not prescribe. I may prescribe 15%, 16%, no more. And as a class, because if I do it with regard to Balmiki or Mazhabi, I'm doing it on the basis of caste. Then I'm foul on 16.2. I have to do it as a class. And this word scheduled caste, scheduled tribe is running throughout, hand in hand. 338, 335, 46, all these articles throughout. Thomas Millard, my respectful submission. Lord, it was submitted that lumping will take place. This is being sought to be answered here in two at one go. That lumping will take place. All the benefits will come to one stand, and this is not a monolith block. The birthmark exists. Not the birthmarks do exist. They exist real as life. Why? Because those entries are there for anybody to read. Open the presidential order of 1950, those birthmarks are there. Those marks itself, originals are there. What birthmarks? They are live as anybody. But they stand eclipsed is my most respectful submission. By the constitutional mandate, by the constitutional scheme. When the scheme says that they now, for the purpose of this constitution, this is my list. This is a constitutional list for the first time. The birthmark of a race, part, caste, tribe, whatever, tribal, all those vanish. It stands eclipsed. So it is heterogeneous and homogeneous at the same time. Heterogeneous at the birth level, at the constitutional level, 341 level, it's eclipsed. It still remains. Anybody can see it. Only eclipsed. That's the aspect of homogeneous and heterogeneous there. And we'll kindly see just one or two observations. I can. Yeah, thank you. Lord, volume
So your
5.
theory that certain pre-existing traits are eclipsed by the constitution
Yes, Lord.
may to a certain extent hold good in the case of political representation. See Article 330, where 330 says that the seat shall be reserved in the House of the people for A, the scheduled castes, right? B, the scheduled tribes.
Yes.
So once it says they shall be reserved for the scheduled castes, the scheduled tribes, there cannot be any further bifurcation of the scheduled castes. It is reserved, and the proportion is indicated in clause 2. So there the constitution has provided a clear indicator that you can't, no state can say, well, I'll reserve only for a few of my castes because they are. For political representation, all the scheduled castes are bunched together as the scheduled caste, the scheduled tribes.
Yes, Lord. Lord, identically, Lord, kindly see 335. The claims of the members of the scheduled caste and the scheduled tribe shall be taken into consideration. I would respectfully submit there is no room to say that the individual entries can be reached. It's being talked of as a class. Members of that class. And kindly see the definitional, my lord. It throws light. 366. Apropos what my lord the Chief Justice is pleased to put to me. 366. 24. 366 bracket 24 thereof. The definition. Scheduled castes means, it's exhaustive, means such castes, races, parts or groups within such caste tribes as are deemed under 341 to be scheduled castes for the purpose of this constitution.
Correct.
We are talking of them as a whole, wherever we are, for the purposes of this constitution. Otherwise, my lord, the moment I would respectfully submit, my lord, the moment we start talking and we start classification on the basis of a entry or another entry, then we will be on the wrong side of 16.2.
Everywhere where scheduled caste or scheduled tribe word is used, starting from 330 and onwards.
Lordship.
But again, going back to 16.4, there is nothing like that. It's only backward class.
Lord, that,
Why not scheduled caste mentioned there?
Lord, why not? Lord,
They
very,
have mentioned it.
Lord, it is explained.
Left
Lord.
it open.
Yes, Lord. Advisedly, Lord, that 15.4 came later. 15.4
Forget 15.4.
15.4 came later. 16.4 is earlier.
It's earlier.
Lord, 16.4 has been explained, and your lordships know that, Lord. That 16.4 includes not only scheduled caste, scheduled tribe, OBCs, and others. The power is not exhaustive. Para 30803 of Indrasani. It's not exhaustive because the language is nothing shall prevent the state from. So there can be another class also.
Exactly.
But when we are talking of 16.4, we are again, my lord, in my most respectful submission, talking of it as a class. Backward class, scheduled caste, scheduled tribe.
Why do you scheduled caste, scheduled tribe, SC, OBC, everyone is included in backward class.
Yes, my lord.
There could be others also.
Also.
So therefore, in identifying where reservation is inadequate representation, the state can decide which
Lord, but
class to be given how much benefit.
But this exercise is not that exercise. This exercise, which is impugned, section 4 bracket 5 of the Punjab Act,
Correct.
is an exercise to puncture the scheduled caste list.
In scheduled castes, they have found that these are backward classes, further classification.
Lord.
Therefore, they are extending that benefit to them.
Yes, Lord.
What is wrong?
Lord, the state has.
The idea is to get equality, to bring them up. So they're trying to bring them up.
Yes.
Others have already come up.
Yes.
So, all right, let others also come up.
Lord, there are two submissions that propose this, Lord. One, that
Why are you resisting that? It's in that class only.
And it is not as if you are deprived.
Yes.
You will still get it. And if they, fortunately, if they can make it, well and good. But if they can't make it, those seats will again fall to you. Why?
Lord, kindly see the
it-
resistance is this. I can't see that.
No, it's like a general bogie of railway compartment.
Everybody wants to get in.
We have got in now, but we will not permit the others to come in
Lord,
once we are in.
Lord, kindly see the bogey example, how it translates on me. I am inside. Lord, kindly see the bogey example, how it translates on reality to me. I am inside, but for the 50%, I'll be excluded. I don't have, I'm there, I'm
Because
still not
the
there.
state has found on some analysis, some survey, some
Some
data
empirical data.
collected, that this is where it has gone down and this is where it will come up.
No, there are two-
Particular.
no, there are-
Therefore, they are trying to equal them.
Like
There are two-
in Tamil Nadu,
Yes.
they have found that those 7 castes which are grouped into one category, they are 35% or 40%.
Out of 76.
Out of 76,
Ah.
but they hardly have 2% representation.
Lord,
So what
kindly
is wrong if some special provision is made for them?
Lord, kindly see the resistance is on two grounds. One, that the moment they pick Mazhabi and Balmiki, the classification is on the basis of caste.
That we'll hear the other side. You
It's on
made
the
the
basis
point.
of caste,
Which
which
is
is
prohibited
found
under,
from
which
16.
is prohibited under 16.2.
16.2 and then not contemplated by 16.4. That's his contention.
Yes, my lord. That's one exception. Second exception to that is that this role they are assuming to themselves.
Which is exclusively with the parliament.
Is the
That we understood. So.
is the respectful submission.
But you know, in 16.4, though it says backward class and not caste, it says any backward class.
Any backward class.
So there can be a class within a class as well.
Lord, I would respectfully
That
submit.
class, only thing is, it can't be an artificial class. States can't, in fact, we are going to ask them that question.
Yes.
States can't say, for my purposes, this is a class.
Yes.
They must demonstrate that it is a class on the basis of an objective criterion.
Yeah.
What is the objective criterion? Lack of representation in the services of the state.
And Lord, here in our case, that class is identified by the Constitution, 341, 342 exercise already done by the President. And that class identified, sealed by the Constitution, given a constitutional status, they want to puncture that, enter into that, translate their wisdom into that on the basis of caste, on the wrong side of 16.2, and say, we have come to this conclusion, Lord, that path is not available. Lord, therefore, I started with this. Is this the constitutional scheme? Do they have a role to play? Is the question which I asked myself.
What your argument is that you can either give the benefit to the entirety of one class, namely the scheduled caste, or you can't give it at all. Don't give it at all. It's your discretion not to give it to at all. But if you give it, you must give it to everybody together.
That's the
So
scheme.
your argument is that if the state finds that you have reached a sufficient stage now, then the state can exclude you.
No, Lord, state can't, Lord.
So
State-
the parliament can exclude you.
Parliament will exclude.
Parliament.
That's his argument.
But
they'll have a role there.
and then if the parliament finds that somebody is some caste which is not included, the parliament has the power to include that caste in 341.
And will not kindly see the language, parts thereof, caste, race, tribes, parts thereof, or groups within. So when it comes to exclusion, when the parliament will exercise the power, they have the benefit of this variegated pieces on the table, so to say. So they can say this part is excluded because of experience. The state will again have a role to play there. I must concede that. Why? Because they will have a role to feed the constitutional tribunal, 338B commission, the constitutional commission, expert body to monitor and to investigate. But kindly see that expression, my lord. It's very wide. The constitutional, the tribunal which is taking me to the next bullet point, my lord.
Mr. Swarup, the only problem is that, if you accept your argument, it will really come down to this. What is a sequitur? You always look at the sequitur.
Yes, my lord.
Sequitur is unless Parliament deletes either a particular caste in the entirety from Article 341 or a part of a group of that caste from 341, if that is not done, then the state is duty bound to give reservation benefits to the entirety of the Article
list as it
341
stands.
list in that state,
As it stands.
even if the consequence would be the capture of benefits by the dominant among the scheduled caste,
I would submit, my lord.
isn't it?
Lord, therefore I submitted on the first date.
So you must necessarily accept a consequence where benefits can be captured by a dominant or a set of dominant castes within the scheduled caste list as a consequence for which the constitution has no answer. The only answer is then go to parliament.
Lord, I would submit, my lord.
Really, that's the consequence. You have to then accept it.
I would respectfully respond this way, my lord. When we are looking at the constitutional
The
scheme,
states have no power to then alter it. They are going to be the people who are going to be funding the posts. They are going to be sanctioning the posts. They are going to create the infrastructure, but you will have no choice of redirecting the channelization of benefits to those who deserve them the most.
Lord, I would submit, my lord, the remedy lies in this fashion, my lord, as I have already submitted. They are not a mute spectator. No, they have to dole out the benefit. They have to be funding it. And it's not as if this inequity is staring them in their face and they can't do anything. It's not that, my lord. The situation is they have a remedy, and this is the mandate of the constitution that please do it this way. Otherwise, my lord, kindly see the other side of the picture.
Delete it from 341 in the
See
entirety.
the other side of the picture. Kindly see the other side of the
So
picture.
take a situation that a particular category has risen up, but not risen up to a particular level. there are other categories who are still at the bottom. So would excluding that category who has reached say, a real ability as contemplated under Article 14 or 16(1)?
Lord, I myself said so, my lord, that fresh experience has a ventilation, my lord. It can't be submitted on this side that fresh experience cannot be. Yes, my lord.
They are being perpetuated still, and they will have to follow the rigor of going to requesting the parliament to make changes. That's your submission.
That we have said that. My lord, question is, my lord, my respectful response is this, my lord. The question really is who to do it.
That
There-
your answer again is it only parliament can do.
There's no debate on this side. There's no contest on this side that yes, if an iniquitous situation is obtaining, it has to be redressed. There can't be a resistance to that. There is none. But
There
who to
appears
do
to-
it?
There appears to be.
No. I'm making, I said so, I'm making it clear that there's no resistance, that fresh experience has to come in. It has to, it's an evolving society, it's an evolving constitution. There's no difficulty on that. But who to do it as per the constitutional mandate is the question, my lord.
Now, Mr. Swarup, we've almost 1.5 hours now. What is the next major head so that we,
Yes, my lord.
you know,
Yes. Lord, I wanted,
drift of your submission and
yes, my lord, I was on Thomas.
Thomas, now just tell us.
Yes, my lord, volume 5, and yes, I'll just get that.
PDF 27.
Just, your lordship, give me a moment. Yes, my lord. Lord, PDF page 96, P96. Lord, I must thank my lords, my lord, that I got acclimatized to working on this. Thanks exclusively to my lords.
Play with it, isn't it?
But for that cajole, I can speak for myself.
Which page you are referring to?
Yes, my lord. This is PDF, my lord, 97.
23.
Volume 5, my lord. Volume 5.
Volume 5.
Volume 5, 165. Yeah, it's- to place 165, my lord. Para 165. My lords have that.
Yes. It's PDF page 96.
If I read 96. we have-
96, I'm grateful, my lord.
In the instant case.
In the instant case, one of the main planks of the arguments put forward by Mr. Abdul Qadir, Learned Advocate General Kerala, this submission is going to be accepted, that so far as scheduled caste, scheduled tribes are concerned, they've been given an exalted and a privileged status under the constitution. And in the directive principles contained in part 4, which a mandate of the state to consider their claims, it is necessary to consider this aspect of the matter in a little detail, because the main argument of Mr. Abdul Qadir has been that the scheduled caste, scheduled tribe are not did not fall at all within the mischief of clause 2 of Article 16, which prohibits discrimination on the ground of caste. The scheduled caste is not a caste as mentioned in 16(2). I'm inclined to agree with the argument advanced by the Learned Advocate General that the word caste appearing after scheduled is really a misnomer and has been used only for the purpose of identifying that particular class of citizens which has a special history of several years behind it. The scheduled castes and the scheduled tribes have been a special class. My respectful emphasis is a special class of citizens who have been so included and described as such, come to be identified as the most backward class of citizens. Lord, therefore, this is again a deeming provision. They have been identified as the most backward. Lord, this is an ipse dixit of the state, Lord, today. That fresh experience, they have not been able to come up. They will place data before the commission. Empirical data. Today it's an ipse dixit on affidavit, and the data across the board vary. Private respondent A will say
We are,
something.
we are not going to that question as to whether the data is sufficient or not.
Right, my lord.
That exercise is on into by
At the appropriate stage.
after we
Lord,
decide the issue.
Lord,
The question is whether
this cloud is sought to be created, that we are facing this iniquitous situation, and therefore we must readily come in and hasten to address that situation. Is a cloud being created? But is that cloud available? Because identified is a special class of citizens who have been so included and described as they come to be identified as the most backward class of citizens we have in our country. This is a run up to reading 5 paragraphs earlier, my lord. I could give your lordships immediately, starting from 124, and this is 165. All these paragraphs, my lord, are devoted to this. Expressions, they are in they are the lowliest, they are the backward of the most backward, and then to culminate to say they are the most backward. In the face of this, for the state to say that we have identified this, no, I would say it's not available to them. They are arguing against N.M. Thomas when they say so. This is the most backward. 169. Kindly turn to one other paragraph, 169, a few paragraphs down. Thus, in view of these provisions, the members of
you read para 167 also.
165 minute?
167.
167, very 167 minute. A combined reading of 46 and clause 24, 25 of 366, that's a definitional, clearly shows that the members of the scheduled caste and the scheduled tribe must be presumed to be backward class of citizens, particularly when the constitution gives the example of scheduled caste and scheduled tribe as being the weaker sections of the society. Constitutionally, my lord, 46 says so. Your lordships have seen it, my lord. 46 says so.
What is also reproduced there, just in a paragraph above that.
Yes, my lord. The state shall promote special care, educational, economic interest, weaker section, in particular of the scheduled caste and scheduled tribe, and shall protect them from social injustice and all forms of exploitation. As a group, no segregation allowed. Whenever we talk of for the purposes of this constitution, look, these are the embargoes on them. What is being asked on the other side is, where is the bar? These are all bars. I have a separate heading of a bar. I'll place that also, my lord. Then 46, 167, and when my learned friend wanted me to read 169. Thus, in view of these provisions, the members of the scheduled caste and scheduled tribe have been given a special status in the constitution, and they constitute a class by themselves. That being position, it follows that they do not fall within the purview of 16(2) of the constitution, which prohibits discrimination between the members of the same caste. If therefore members of the scheduled caste and scheduled tribes are not caste, then it is open to the state to make reasonable classification in order to advance or lift these classes so that they may be able to properly represent the services under the state. Undoubtedly, this can be done under 16(1) of the constitution. Yes, plus please do it as such for the entirety of it. Please don't bifurcate. Why? Because they are the lowliest and they form a class by themselves. Binding on all of us, my lord. N.M. Thomas says it, and they are arguing right in the contrary to this. Give me that solutions. What this was read. Lord, Andhra, I want in item 4, my lord. I'm in the bullet point 3. Now I just need to touch one or two aspects, my lord. I think I have. Lord, in item 4 and the bullet point 3, the Andhra example is given that all these shades of ingenuity, if I may call it, with the utmost respect, will come up. What is that ingenuity in Andhra now? Punjab experience, your lordship have seen. 76 is my total entry
Out of which 7 have been clubbed together,
Seven-
Arundhati.
as one,
Tamil Nadu is Tamil Nadu.
Tamil Nadu.
Tamil Nadu, actually, not Andhra.
Thank you.
That is,
Tamil
you'll have to
Nadu.
correct that. Huh?
Lord, my mistake. Tamil Nadu, Lord. Lord, why? I was asking myself this question, why 7? Because it can be argued that they are a class by themselves. If I come 1-to-1, Balmiki and Mazhabi, I may be criticized of 16-2. This is the ingenuity which will come up. And that is exactly what Dr. Ambedkar said no to. We don't want political factors to come in. We don't want any disturbance in the list. N number of situations and ingenuities will come in to factorize in that, no, we are not including, excluding. But Lord, as it fell from my Lord, this is his first day, that this is virtual exclusion. This is my virtual exclusion.
Not an exclusion.
I'm sorry, Lord.
Among the reserve categories, only they have been given preference for 50% of the seats.
Yes, Lord.
So you can also compete for the 50%.
For the
But-
balance 50%.
No.
Ah.
But no. You can even compete if suppose a sufficient number of candidates it's a preferential allotment.
Yes.
So it's not a quota which is exclusively reserved for these 2 posts.
Yes.
To these communities. In Tamil Nadu. No, so it's only a preferential allotment.
In Punjab, first
So,
preference.
sorry, Tamil Nadu it is there. I mean, in
Punjab.
Punjab, it
First
says it's-
preference.
yeah, it's first preference.
Yes. Lord, kindly see me, Lord. To the extent of the first
So according to
preference.
you, among that category,
Yes.
the survival of the fittest has to be followed. So who are based among that category,
Hmm.
irrespective of the relative degree of backwardness, they will get the post.
Lord, I'm
What has been done in percentages has been
Where?
in Andhra, ABCD category, 7%, 1%, 1%. So, my lord, what we were getting earlier gets reduced, my lord. So that would be the factor, my lord. Apart from the other, this thing, my lord, whether the state has power or not, which in my submissions, they don't have. I wanted to distinguish, my lord, Chinnaya with the other matter. The submission is, my lord, if your lordships read, my lord, 15-4 and 16-4, 15 exclusively deals with SC, ST, my lord, which words your lordship will not find in 16. To that extent, my lord, once it is a class as a whole, it is a class of weaker sections or uneducated or lowly income, my lord. It will not say, my lord, that scheduled caste or scheduled tribes.
But 15.4 also does not exclusively deal with the SCs and STs.
Education backward class of
Kindly-
citizens or for scheduled caste and scheduled tribes.
Right, my lord.
It says
15-4,
as 15.4 also uses the expression socially and educationally backward class.
backward within them, my lord.
No. Or for the scheduled class and scheduled tribe.
Separately.
Backward class, socially and educationally backward class of citizens or for the scheduled caste and scheduled tribes.
Right.
So 16.4 is actually broader than 15.4.
Broader, my lord.
Because 16.4 may include some backward classes which are not scheduled caste and scheduled tribes,
Right.
and strictly speaking cannot be regarded as socially and educationally backward classes of citizens.
In other words, it's being said, it's not exhaustive of the power.
That's all. So 16.4 may possibly be wider than.
Said so,
15.4.
my lord, 803 of
That's
Indra
right.
Thani. Said so already, that it is wider. And the opening language of 16.4, nothing in this article
Right.
will prevent. Those words were.
And the words is not adequately represented in the service under the state.
Lord, this brings me, my lord, if I lordships permit me a few moments further.
You would ought to take into consideration the word that is not adequately represented in the service under the state.
Not there, that the exercise of 16.4 is not adequately represented, is a prerogative they exercise.
So therefore,
Yes,
amongst that class, if the state finds that
not
a
adequate.
class among that class
Is
is
not
not
adequate.
adequately represented,
Yes.
whether it will be debarred from taking an affirmative action under 16.4 to remove those inequalities.
Lord, submission is 16.4 is indeed using that expression not adequately represented, but it is targeting what? The class as such.
According to you, when the state goes into underrepresentation, it must look into underrepresentation of the scheduled caste as a whole in that state, not that particular, not that particular community within
If
the.
they do so, my lord, if they do so,
That will be, that will be.
16.2, then they are doing so,
Contrary to
they will,
16.2.
and they will come out with an affirmative action by legislation or an executive order. If the state wants to address that situation, that we find that in this scheduled caste, we find that these people are eating away all the vacancies, they will have to come up with an affirmative action.
So to
If
put
they
it, look
do
at,
so-
look at it like this, suppose the state finds that, say, a caste which has hitherto been doing predominantly the occupation of manual scavenging, right? They are underrepresented in the services of the state.
Yes,
The state can't take any action. Why? Because if as a whole, the scheduled castes are not underrepresented in the services of the state, then though there may be certain communities, I give you the classical example of those who are hitherto engaging in manual scavenging. State government then has no power because you have to look at the overall scheduled caste. You can look at the micro picture in relation to any of these castes.
And-
But according to you, a caste is not a class. That's the argument.
if they do so, my lord, then it will be on the basis of a caste, which will exactly fall on 16.2. That will be a classification on the basis of caste. This is one reason. Second reason, they have no role to play. They have played their role. Lord, answering 16.4, my lord, en bloc state they find unrepresented, then they will do so for the entire block, because any backward class of citizens, which will include SC, ST, OBCs and others, but as a class. It's not as if, as I submitted, the situation is remediless. Yes, there is a root, but state has no role, and they.
What is the root? According to you,
Yes, my lord.
you said that the words used is only add, include or exclude. You yourself argued that it is not permissible even to vary that.
It's certainly not. The root is this.
Therefore,
The root is this.
Again, I have to put it the same question. If
Yes.
the state finds that
Yes.
A caste has reached up to 75%, but not 100%,
Yes.
and D caste is only at 10%.
Yes, my lord.
So either exclude A, though it has not reached 100%, and continue with the others. Would it not be injurious to you if the state does that? Or if the state recommends the parliament to do that, and the parliament does that?
Probably the root is 342A3. Kindly read it.
Yes, my lord. The third part of it, yes. The state list. The state list.
State by law,
Yes, lordship.
notwithstanding anything contained.
342.3. 342A3.
342A3.
But that is only for
SCBC.
SCBC.
Right,
Yes.
that class can be included in.
No, but it's-
Yes.
Duty has been cast to maintain.
Give me that. Three. Give me that 3.
Well, yeah, body, yeah.
What yes, may I have?
Notwithstanding anything contained.
A3. Yes.
Notwithstanding-
Notwithstanding anything contained in 1 and 2. I'm reading 3, 4. I'm sorry.
Yeah, 342, A3.
Yeah.
State has no power. Central list. It may be different.
See, my lord's question, my lord, and then I just immediately thereafter read 342A also. My lord, this is Gawai's question. They find that this is the data, some one caste has gone up. Lord,
They don't say one caste has gone up. They say that these two castes
have been left behind.
have no representation at all.
Lord, kindly see.
Far behind.
Lord, kindly see the iniquitous situation. There is no assertion on record from
We
the
are not
state.
going to the sufficiency of the
That
data.
High Court will test for this, yeah, because that
We have
point
only
is
to
not
see
been
whether
tested.
they have the power or not.
Whether,
We
you know,
just
they
want
had,
it.
whether they had collected data, whether they have data, what should be the threshold requirement, that we'll also lay down.
Yes.
Because it can't be that the states can just do it, everything at their whims and fancies.
Yes.
Obviously, the state is also duty bound because to act in accordance with the constitutional mandate, and they must have objective data, quantifiable data, as we have said. And that the High Court will test ultimately whether
Lord,
they
may I
have.
just
stood
formulate
that
this
or
submission
not.
which I'm wanting to make. Mazhabi and Balmikis are taken up by this. Lord, is it to be accepted that none of these categories have advanced? There is an inherent
Again, you are
presumption.
going into the rationale of doing it.
That
Question
is
is
not
whether
the-
they have the
this is
power
not
or
the
not.
stage,
We are not
because-
going to the rationale.
Yes,
We are only.
We are
questioning
testing the correctness of Chennai.
yes, my lord, yes, yes. Lord, I wanted to read 342A, my lord, and 3 thereof. And this is, of course, in the background of socially and educationally backward. Yes, my lord. 3 thereof. Nothing contained in clauses 1 and 2, every state or union territory may by law prepare, maintain for its own purpose a list of socially, educationally backward classes of entries to which may be different from the central list.
So it is presumed that SCs and STs are socially and educationally backward.
Yes.
They are the most backward class of the backward class. So that can also be done. This could be the route through which, if one finds that a particular caste is not being included, has not been included. So this could be included by way of 344A3. Probably.
Lord, each of them, each of these categories in 341, 42, 42A, they have a commission. Now we have a commission, a constitutional commission, which will advise and will send it, as I submitted, to the president. And there the fresh experience comes in. That's the route identified. They are trying to find a route in 16.4. 16.4 is only that you may give percentage of reservation. Yes, indeed so. It's a purpose. It's in part 3 that yes, nothing will prevent the state from making that provision. For that
You know,
purpose,
Mr. Saru, actually the constitution has used 3 expressions: backward class, scheduled castes and scheduled tribes, and socially and educationally backward classes of citizens. Though backward class will include the socially and educationally backward classes of citizens and scheduled castes and scheduled tribes.
yes, Lord.
Perhaps the scheduled castes and scheduled tribes as a grouping cannot fall within the SEBCs.
They don't.
They are very distinct.
They are distinct, Lord. No
Therefore, you know, apropos my sister's question, when the state is exercising the power under 342A3, they can't exclude the SCs and STs or any part of the part thereof in exercise of the power under 342A3. Because 15.4 clearly specifies the scheduled castes and scheduled tribes as a distinct conglomeration from socially and educationally backward classes of citizens.
Yes.
16.4 makes that very clear, that it says for the advancement of any socially and educationally backward classes of citizens or for the scheduled caste or scheduled tribe.
Yes.
If the scheduled caste and scheduled tribes were deemed to be a part of SEBC, there was no need to refer to them specifically in 15.4. But 16.4 is much broader. Therefore, it just says backward class, which will include the socially and educationally backward, the scheduled caste,
Yes.
the scheduled tribes, so on and so forth.
Indeed, so.
And any other backward class as well.
And that expression any, my lord, in 16.4, when they say any
Any.
backward class of citizens, now again talk of class, not any member of that class.
That is the point really. That's the point which they have to meet actually.
Lord,
That
that
is
takes
first
me, my
to a
lord,
class.
if your lordships kindly permit, it is being said, Chennai, that takes me to point 5, my lord, that Chennaiya judgment is per incurium because it doesn't have a discussion on the interplay 341.1 and 16.4. That was argued, my lord.
Can you give us the paras of which in Chinaya, which
I've
according
given-
to they discuss it?
I've given it immediately there, my lord, 31 and 50. Right in the heading, my lord, the Chief Justice has. In the heading 5,
Yes, yes. Oh, sorry, yes.
I'm sorry, my lord, it's there. In para 31 and 50.
So Chinaya does discuss the interrelationship.
Yes, my lord, it does. And it attributes the role, identification role, if I may summarize, if I paraphrase in my own way.
1 and 4.
Yes, my lord, in a moment, my lord. 796 of volume 5, my lord. Sorry. And at page, my lord, this is. Yes, my lord.
At page
At 798, my lord, my mistake. 798 of
798.
volume 5, my lord, PDF page.
let me just look at it quickly. Yes.
And this is the judgment, Justice Hegde's judgment. In 31. What would be said is, the content of 341 will be first considered. I'm sorry. My lord, 31 at PDF 798, my lord, of volume 5.
Between Placidum E and F.
Yes, my lord. And above that is the content of 341. And below that, as my lord's justice is pointing out, my lord, is the consideration of 16.4. Can I place that, my lord?
Yes.
On a detailed perusal of the Act, it is seen that Section 3 is the only substantive provision in the Act. Rest of the provisions are only procedural. Section 3 of the Act provides for creation of 4 groups of the caste enumerated in the presidential list of the state. After regrouping, it provides for proportionate allotment of reservation already made in favor of the scheduled caste among the 4 groups. Beyond that, the Act does not provide for anything else, since the state has already allotted 15% of the total quota of the reservation available to the backward classes, to the scheduled caste. The question of allotting any reservation under this enactment to the backward classes does not arise. Therefore, it is clear that the purpose of the true intendment of the Act is only to first divide the castes in the presidential list of the scheduled caste into 4 groups, and then divide 15% of the reservation allotted to the scheduled caste as a class among them. This is clear that the Act does not for the first time provide for reservation of scheduled caste, but only intends to redistribute the reservation already made by subclassifying the scheduled caste, which is otherwise held to be a class by itself. And then, my lord, well settled principle in law that reservation to a backward class is not a constitutional mandate. It is the prerogative of the state concerned if they desire, with the object of providing opportunity of advancement in the society to.
Classification, in the classification, there was a sub-classification,
Yes, ma'am.
not on the basis of caste, but on the basis of the empirical data of not adequately being represented.
Yes.
Then how would it hit Article 16.2? And it is not a discrimination on the basis of a caste.
Lord, this is to summate, Lord, those were 4 groups made in Chennai case. The criticism on the other side was that 341 vis-a-vis 16.4 is not even, has not been considered, and therefore per incurium. To that, my lord, what I wanted to submit was that the content of 341 and the content of 340, the 16.4 has been considered by the honorable court in that bench in these 2 paragraphs.
Apropos what my learned brother said, 16.2 uses the expression only,
Only on the ground.
right?
Yes.
Therefore, if the positive discrimination, if we can call it that way, in favor of these 2 communities is made not on the basis of caste alone, but on an objective factor, namely underrepresentation, which is contemplated by 16.4, then it may not offend against 16.2.
But kindly look how the language of the statute is cast. The 4(5) of the Punjab Act. These 2 categories are picked up, these 2 castes are picked up, Mazhabi and Balmikis, and a legislation for that. So the target group, so to say, is the caste, which according to our submission is foul on 16(2).
If they fail on underrepresentation, then it's a discrimination on the grounds of caste. But if they are right on underrepresentation, then it's not a discrimination on the basis of caste, because then it is based on objective criteria, namely the extent of the underrepresented.
I don't think there was no data when.
We are not going to that
That
question
may
whether
be
there is
right
data
also,
or
that
not.
High Court will deal with that.
Whether there was a data or not, or whether the data was sufficient or not.
And it was saying when this was framed out, there was no such thing.
That, I mean, if you are right, the High Court will have to deal with that argument that you had no quantifiable data at all when you made that.
Lord, when
Like Mara, it is-
this data also in the, your lordship would kindly
To sufficiency, insufficiency, existence, non-existence of data. The question is whether the state is powerless or not.
on the constitutional plane I could submit, when when Thomas lays down as a law that they are a class by themselves and that they are the lowliest. Lord, then for the state to say otherwise is by submission
State
is
can
not
go-
available to them.
According to you, the state cannot go into the question of lowliest among the lowliest.
Lord, this is, they have reached the rock bottom. And also, Lord, kindly see, this is one side of the picture that fresh experience and there may be inequalities and we want to redress it. This is one part. There's another part. That there may not be a political tinkering with this. And this is an all India feature now. We don't want a situation, the constitutional mandate, the constitutional
The
debate.
courts are there under Article 226. The courts can always examine whether the decision taken by them is on the basis of empirical data or not. It can always be found that as to whether the action proposed has a nexus with the object or not.
Lord, my submission is, my lord, why is this freezing exercise being done? If I may call it. Why is this freezing exercise being done? Why is this insulation exercise being done? To take away any aspect of political tinkering. The danger writ large, even at the time of framing, which your lordship, that passage has been seen. These are the two competing factors. Inequalities removal and the political tinkering. This has to be balanced. Therefore, the court is saying in Thomas that this is a class by itself. Now, how does the state enter into that class? In my respectful submission, they can't. Without doing violation too. It's a class by itself. It's a special class. To use two exact expressions in 165 of Thomas. At the lowest rung. Now, where is the opportunity for the state to say, no, our experience is this, our legislation is this? No. Is my respectful submission, my lord.
And we will have to take into consideration the future possibility. Forget Punjab. Punjab doesn't make any reservation for scheduled tribe, a particular.
Yes, lord.
Other states may make for a particular scheduled tribe,
Yes,
particular scheduled caste.
yes.
That would be in exclusion of other scheduled castes and other tribes. So that may create a situation which may amount to discrimination amongst the members of the scheduled caste and scheduled tribes.
And scheduled caste, scheduled tribes, all taken to be the lowliest and to constitute a class. When held by Thomas, they want to pierce that. The entire effort is to pierce that. Lord Indra, Lord, I have one last of this first page in item 7, this Jayashree Patil Milord judgment said so, apropos my lord's question, that 342A brings in a new regime. 342A, those three articles which come in 2018, is being said in Jayashree. I could give the paragraph. The exact expression used is that it brings in a new regime. Vis-a-vis the Indrasani. It was compared. I could give that.
Yes.
Just give me a moment. Yes,
SC Patil is 1466.
yes,
PDF.
Milord. Yes. At Milord PDF 1605, Milord, in paragraph 157, 158, particularly 158, volume 5, Milord, PDF 1605. These are the conclusions, my lord. I must first place that at 158, SCC page 140, my lord. 158 paragraph of SCC. The evolution from Indrasani, etc., all being noticed. 2018 noticed, select committee noticed, and then the culmination. Can I place that note?
Yes.
At 158, this sequitur is only reason why changes are envisaged in the first place by the parliament, sitting in its constituent capacity, no less, which is to alter the entire regime by ensuring that the final say in the matter of identification of SCBCs would follow the same pattern as exists in relation to the most backward class of citizens, that is the SC and ST, through Article 338, 338A, 341, 342. Too much cannot be read into the expression centralist. That controversy your lordships have seen. That was redressed by bringing in centralist in 342A later on. That clarification came. And I could read one or two, my lord, conclusions in Patil, which are on the same page, my lord, at 156, in paragraph 156, just above, my lord. 156.2, the use of the expression means interpreted to imply exhaustive definitional expression. That expression used in 366, the definitional one. And then if your lordships just come a little further down, my lord, 156.5, the expression of the use of expression for the purpose of this constitution also emphasizes the idea that for all purposes under article this, only the communities or classes deemed to be SEBCs under 342A would be treated as such in relation to the state. And then this conclusion. Kindly see the end of 156, my lord. Paragraph 156, the last few expressions. These expressions are omitted and an entirely new provision exclusively for the purpose of socially and educationally backward classes are inserted. That is the Commission 338B, which has independently consider all aspects relating to SEBCs in the manner identical to SC/STs. So it's a constitutional commission which will consider the entire data. If I can take a few moments on item 10 on the page next minute. But what was said is creamy layer, as if suggested creamy layer suggested is accepted norm in SC/ST. Lord, that is in the light of Nagraja and that is in the light of Karnal, which were promotional Jarnail Singh, which were 4A and 4B situations of 16, promotional, not at the entry point.
So according to you, that's what, because as Mr. Gopal Shankaran said, so far no government, including the central government, have issued any office memorandum that a creamy layer would be applicable to scheduled caste, scheduled tribe also.
Yes, Lord, none at all to our notice as well, none at all. But what is being suggested is that there, by the root of creamy layer, the class of SCs is available for dissection. Yes. Exactly. It's a work in progress. उसमें क्या मतलब होता है उसका? उसका क्या? But the suggestion on the other side, or the submission on the other side was, as if to say, that at one point the state volunteered to say work in progress. When creamy layer was posed by the Honorable Court, the state government volunteered work in progress. That's the exact response, my lord. But when creamy layer is being suggested, what is being suggested is that when we can enter into the list, when we can bifurcate the list on the threshold of creamy layer, why can't it be done? That means it's pierceable. That means it is subdivisionable. That is being suggested, my lord. And in that aid, Indra Sahni, Nagaraja, Ashok Kumar, and Jarnail Singh are being cited. What I would submit is, my lord, Indra Sahni specifically said when it was permitting classification backward and more backward, in paragraphs after paragraphs, that we are not talking of scheduled caste and scheduled tribes. Your lordships have seen that paragraphs. That's one. Nagaraja is a promotional case. 16(4)(a), 4(b) for scheduled caste, scheduled tribes. So not at level 1, at level 2. We are at level 1 situation. So therefore, very different to talk of Nagaraja, very different to talk of Jarnail. Ashok Kumar Thakur, again Constitution Bench judgment, which is interspaced between the two, between the last two in item 10 of mine, between Nagaraja and Jarnail, Ashok Kumar Thakur comes, which is the validity of 15(5). Can make special provision for admission to educational institutions. The state can. So entry point, there they say no creamy layer. That's the correct position according to us.
So the persons from scheduled caste who are now in a much advantageous situation, they should also continue to get the benefits of scheduled caste.
But those who are, my lord,
A
those
scheduled
who are
caste
in the
person,
position, your lordship say they will continue to get that benefit.
you are saying that no creamy layer. So scheduled caste persons whose child takes education in say Shriram school or Sanskriti, and a person residing in some small village taking education in a Gram Panchayat school, he will compete with the son of a man who is taking education in the best of the schools in Delhi. This is what is meant by Article 14.
Lord, there has to be, Lord, I myself said there has to be a redressal if such situation comes. The route is there, but who is to address that situation is the question, Lord. Is the state to enter into it on the anvil of 16(4)?
So whether in last 75 years, whether a same family should get benefit of reservation on 4 occasions, 4 generations.
No, the answer emphatically has to be no, my Lord.
And the persons residing in the villages to perpetuate to live in those situations.
Perhaps before even.
So that is not a question before us.
Yes, my Lord, yes, indeed.
But the question your lordship has asked, that has been answered already by That's why the reservation was given. Only it was
Right,
objected.
what else, Mr. Swaroop, anything now?
Lord, I'll just, on the last two, Lord, on the last 2 points, if your lordships kindly permit, Lord, very, very briefly. Lord, what was argued yesterday in the second half, later session was vertical and horizontal reservation. Lord, this doesn't qualify for intersectional. This is not intersectional reservation at all. It is not. This is item 12, my lord, in bullet point number 1. This is sub-vertical reservation. Because your lordships know, my lord, this has been dealt with in, if at all an authority was required, in para 812 of Indrasani, that horizontal and vertical, how do they work? And when do we have horizontal? That the horizontal position he can occupy in any of the verticals. Now here the Mazhabi and the Valmikis are staking claim only against one vertical, that is the scheduled caste. So there's no question of intersectional here. A solution being found that intersectional can be considered in this case. But I would respectfully submit no, my lord. This is sub-vertical. And that takes me to the last two, my lord. Where is the bar? It was repeatedly asked on the other side. Lord, my answers are these, my lord, these 4 answers. The bar is 16.2. Where is the bar to state and taking into this endeavor? The bar is 16.2. You are identifying on the basis of caste.
But 16.2 says only on the basis.
But 16.4.
Lord, kindly see the target. Lord, kindly see the target group.
And you know, there is of course,
Ah.
following Nargesh Mirza and that line of cases, I have also dealt with it in my judgment in Sabrimala. 16.2 at one stage, for instance, suppose you know you discriminate against women, right? For instance, you say that a married woman will not be entitled to continue as an air hostess.
Yes.
The argument was that this is not a violation of 16.2 because we are not discrimination only on the grounds of gender, but we are discriminating on the grounds of gender plus. Now, our court has now increasingly, after Nargesh Mirza of 83, our court has increasingly said that you can't get around that only phrase in Article 16.2 by adopting some other prohibited ground of discrimination and then say that, oh no, I'm not discriminating against you only because you are a woman. I'm discriminating against you because you are a woman and you have got married. That is inconceivable.
Yes.
But here, it's not just a discrimination only on the basis of caste. It's on the basis of a factor which is recognized by the Constitution itself in 16.4. Right? Because 16.4 expressly speaks of underrepresentation. So then it is not discrimination only on the grounds of caste under 16.2.
Gotcha. But then I respectfully submit in the second bullet point, the bar is to be inferred from 341.2 that a route is provided. So all other routes are excluded. I submitted, my lord.
Right.
And then the bar is that scheduled caste as a
That
whole
you have-
have been accepted as a class, which I
That you
submitted.
have already made.
And then the bar in the last bullet point in 338, that there is a route of the commission, a committee, etc. Now kindly see, my lord, these paragraphs I have mentioned in Devinder.
That's the referring order, right?
Yes, my lord, these 4 or 5 paragraphs.
We look at them. What are you trying?
Submission is this, my lord. A reading of these paragraphs, my lord, is this. State cannot be denuded of its power. State has to run to the aid and to ameliorate the situation. Lord, these are answers in generality with utmost respect. These are not constitutional answers to upset Chinaiya or to meet the reasoning and the findings of Thomas. These are the spate of reasonings running into these 5 paragraphs. That of course the state must have the power to do this. It is not as if there is no ventilation to the grievance. Yes, there is, but there's a route. There's a person identified who will do it as per the constitutional scheme. All these paragraphs run in that tenure. That's the respectful submission.
Thank
Very
you, Mr.
grateful, my
Swaroop.
lord.
Thank you, Mr. Swaroop.
And I far exceeded, my lord, your lordship's time.
No, but you are opening.
My apologies for that.
No, you are opening the arguments for your side. So thank you, Mr. Swaroop.
May it please my lords.
Yes.
My lords,
Yes.
much of the ground has been already covered by I won't take much time, which I have already told. I will only submit regard to the, my lord, one thing, the questions framed by that. The first question was whether the provisions of the contained in section 4, subclass 5 of the Punjab Scheduled Act, Backward Classes Act are constitutionally valid, or whether the state has a legislative competence to enact the provisions contained in section 4, subclass 5 of the Act, whether the decision in E.V. Chennaiya versus State of Andhra Pradesh, I reported in 2005, Volume 1, SCC 397, required to be revisited. The number 3, my lord, I will address first. Your lordship may see whether yes, sir. My lord, I have already, these submissions have been submitted by my learned friend, Mr. I'll be following that. And that is at Volume 2, page 19. And the relevant which would be at page 23. Heading which has been given already there.
You are referring to Mr. Hegde's submissions.
These were submissions, my lord, before the 5 judges, and I have got the advantage of.
Only 1 second, Mr. Agar. Mr. Sarup, which is the, what is the cross reference to your original submissions? Because you gave us 2E, we read that 2-page note. But where are your original submissions, the more comprehensive submissions? You can just give us so that, well, in our notes, we don't miss it. You can, before we rise, you can tell us.
It is on page 76, page PDF, volume 2.
Volume 2,
Page 76 PDF.
we got it, Mr. 76 to 91. Volume 2.
But I also had the answer to Usha Mehra, if your lordship want at this stage.
Mr. Sagar, you are.
Yes, my lords, I was. Now, your lordship may refer to page 28 of my submissions and the para number 3, in which I have very categorically stated that the appellant sought to contend that the decision in E.V. Chennaiya does not follow the judgment of a larger bench of this honorable court. Indra Sani versus Union of India,
You are referring to para 3.
para 3, my lords.
Para 3 begins with the Punjab government by a circular.
No.
You are referring to Mr.
Page-
Hegde's submission.
Page 20, page 28, internal page 10 of the submissions.
Internal page 10.
28, man. Volume 2,
Volume 2, Mr. Hegde's submissions begin at PDF page 19.
yes, that is, now you're not.
You are referring to your submissions or Mr. Hegde's submissions?
It is Hegde's submissions, my lord, I have said so. It has already been submitted by Mr. Hegde. So I am addressing on
The
those very submissions.
Punjab government by a circular, right?
Yes,
All right, that's PDF page 21 in volume 2.
yes.
Just one second.
Now, my lords, I may have page 28. In this, may I start? May I? Page 28.
Class 3.
Yes,
The petitioners, appellants have sought to contest.
yes, my lord, this,
Yes, my
I'm very sorry for little
No, no.
inconvenience, my lord. Does not follow. This, according to us, is not right. It is absolutely incorrect. And the judgment in Indrasani permitting subclassification was limited, as already stated by my learned friend Sarup, that only other backward classes. I'll be referring, my lord, certain paragraphs. And further, it has in fact been, court has specifically stated that none of these observations will apply to scheduled caste and scheduled tribes. The relevant portions are here, my lord, 781. But I'll first address, my lords, have asked one question there. Your lordship may kindly refer to, your lordship may kindly refer, all right, to these very 81. 781, at the outset, we may state for the purpose of this discussion that we keep aside the scheduled tribes and scheduled caste, since they are admittedly included within the backward classes, except to remark that the backward classes contemplated by Article 16.4 do comprise some caste, For it cannot be denied the scheduled caste includes quite a few classes. Then, my lord, 788 is the next para. Further, if we keep in mind the context in which the Article 16 subclass 4 was enacted, it would be clear that the accent upon the social backwardness, it goes without saying that the in the Indian context, the social backwardness leads to educational backwardness, so both of them together lead to poverty, which in turn breeds and perpetuates the social and educational backwardness. They feed upon each other, constituting a vicious circle. It is a well-known fact that till independence of the administrative apparatus was manned almost exclusively by the members of upper caste, the Shudras, scheduled caste, scheduled tribes, and other similar backward class social grouping among the Muslim Christians, practically to entry into the administrative apparatus. It was this imbalance which was sought to be redressed by proving for reservation in favor of the backward classes. In the sense, Dr. Rajiv Dhawan may be right when he says that the object of Article 44 was empowerment of the backward classes. The idea was to enable them to share the state power. We accordingly of the opinion that backwardness contemplated under Article 16.4 is mainly a social backwardness, and it would not be correct to say that the backwardness under 16.4 should be both social and educational. The scheduled tribes and scheduled castes are without doubt a backward for the purposes of class. No one has suggested that they should satisfy the test of social end. While in this regard, then the further, my lord, the two paragraphs are more important. And if I may permit, I'll also say, though these have been many a times stated so, this support my submissions. We may now summarize our discussion under question number 3A. A caste will quite often be a social class in India. If it is a backward socially, it would be backward class for the purposes of 16.4. Among non-Hindus, there are several occupational groups, sects, and the denominations which for historical reasons are backward. They too represent the backward social collectivities for the purpose of Article 16.4. B. Neither the Constitution nor the law prescribes the procedure or the method for identification of backward class, nor it is possible or advisable for the court to lay down any such procedure or method. It must be left to the authority to be appointed to identify. It can adopt a method procedure it thinks convenient, so long as survey covers the entire populace. No objection can be taken to it. Identification of the backward classes can be certainly done with the reference to the caste along with others, groups, classes, sections of people. One can start the process with the caste wherever they are found, apply the criteria evolved determining the backwardness, and find out whether it satisfies the criteria. If does, what emerges is the backward class of citizen within the meaning and for the purposes of Section 4. Similar process can be adopted by the case of other occupational groups, communities, classes, so as to cover the entire populace. The central idea and overall objective should be considered all available groups, sections, classes in society. Since the caste represent an existing identifiable social group class in passing the overwhelming majority of country's population, one can well be begin with it and then go to other groups. Section and classes C. It is not necessary for the class to be designated as backward class. It is situated similarly to the scheduled caste, scheduled tribes. D. Creamy layer can be and must be excluded. It is not correct to say the backward class contemplated by the Article 64 is limited to the socially and educationally backward classes referred in Article 15.4 and 340. It is much wider. The test or the requirement of social educational backward class cannot be applied to scheduled caste and scheduled tribe, who undebatably fall within the expression of backward class citizen. The accent of the section Article 16.4 appears to be a social backwardness. Of course, social backwardness, education, and all are closely intertwined with the Indian concept. The classes contemplated in the article may be wider than those terms. my lord, in this, my respectful submission in this case is that which I'll be also addressing other paragraphs. India's Indira Sahni's case, sorry, very sorry, I say. Indira Sahni's case very categorically states and give a finding under what circumstances the concept of creamy layer has to be applied. When the ultimate finding was given that yes, the backward class can be subdivided. There are 7 paragraphs preceding this, my lord, in which the deep concern was shown about the rise of the creamy layer, the rise of those persons in the backward class, may it be any in the backward class, which at the cost of others, they say, they have risen so high. Even Krishna Iyer's in his judgment, Rangachari has also shown this very concern. So it was this concern which actually, I must say, that led to the court to reach on conclusion that it can be subdivided, the backward class can be subdivided. Now, before, my lord, which I'll be addressing post-lunch period, that whether these very circumstances warranted the state to subclass scheduled caste and scheduled tribes, with very utmost respect, whether there was any material to show that the other castes have risen very high, or
Mr. Sagar, that, as we have been repeatedly saying, is a matter which will go back to.
yes, that, but I am
so
just
that can't
preface.
they
It
decide,
is a
yeah.
preface to that, not I am going to address on that issue. Only on this, whether in these very circumstances, they might have, it's a possibility that these 2 castes, Majbi Sikhs and Valmikis, have been suffering, and they are weakest among the weak. On this very issue, I'll be addressing this approach of the court. This very government was erroneous, absolutely, because other classes, if Mr. Sibbal has also, my lord, showed to your lordship, 39 classes, in which many other, like, for example, cobbler, like, for example, snake charmer. And when I verified from that, my lord, these very castes have no houses. In the village, they are asked to live in huts outside the village. They are on abject poverty. Some of them indulge in, your lordship may see, theft, etc., which may not be an issue here. The question here is, their non-applicability of mind may be influenced by the political, whatever it is, but their approach was perfectly incorrect, which I would be.
We'll break for lunch and come back. after.
Certainly, I get full, my lord.
I know that it is the, what happened to that Justice Ulsa Mehta committee report.
Yes.
Private member we heard which was lapsed, so have that been.
Oh, I see.
I'll report.